And joining us now is the lawyer who represents those 10 plaintiffs, Shay Allen. Good to have you from Chicago representing these your clients. JB Pritzker and Juliana Stratton are essentially painting your effort here as a shakedown artist, or an act of extortion almost, if you will. How would you respond to that, and why now, 3 weeks before the election?
Right. Well, first of all, thank you for having me today. And I would say it's unfortunate that the campaign would categorize or try to shape a lawsuit in this way. What it does is it exemplifies, I think, how the campaign handled all of my clients' issues to begin with. To say that someone fighting for their civil rights, someone fighting for their dignity and self-respect is extortion is, I think, an unusual response, to say the least.
How do you settle on that price tag, $7.5 million?
Well, you know, when you come to the price tag, if someone has a problem with that, they need to look in the mirror and see how much your own self-dignity is worth, how much is your respect worth. In any civil lawsuit, there are damages. It's based on emotional trauma. It's based on lack of opportunity to move forward or being promoted, and other factors. The number is a number that we came up with, but it's not set. At any rate, how much is your dignity worth?
They also mentioned that the timeline or the deadline that you gave them wasn't a good faith effort. I think they said 24 hours. It may have been one business day or so. Do you think you gave them enough time to respond adequately?
Well, what was said was 24 hours, so it wasn't 24 hours. We actually had initial contact on October 5th, and then that was Friday. And in the campaign, there are no weekends, there are no off days. So there was Friday, Saturday, Sunday, and then Monday. And we got reached out to at the end of the day on Monday. But even after that, we didn't file the lawsuit till a week and a half later. So there was still correspondence and there was still time. So we made a good faith effort. I don't believe that they made a good faith effort to actually discuss this case on an actual meaningful basis.
And so I'm going to get into some of the specific instances that you cite in the lawsuit in a moment. But first, before we do that, for our audience's sake, what is the standard in a civil suit? How do you prove that discrimination occurred?
Yeah, so the standard in a civil suit, of course, is preponderance of the evidence. So in essence, more likely than not that what we're saying occurred. But in a civil suit, we have to prove that our group, which are minorities, were treated differently than different groups of people in the campaign.
And you don't dispute that 45% of the Pritzker campaign staff is made up of minorities. In fact, I think your lawsuit even acknowledges that.
Right. I personally haven't researched that number, but I don't care if it's 99%. If there are people who are in the organization who've had valid complaints and there is a practice of treating those folk differently from other people, then there's a problem.
Some people are scratching their heads wondering why so many of the plaintiffs in your lawsuit are still active on social media declaring their public support for JB's candidacy for governor. Why do you think that is?
Well, they had a job to do. They signed up to do a job. They're all honest, hardworking, good people. Many of them have prior experience on political campaigns. So just like anyone else, if you have a job to do, you're going to do it. Because it's been very, very difficult for them, doesn't mean that they're going to quit. It doesn't mean that they're going to still not try to do the job they were hired to do.
And you've said that you've insisted over and over again that this lawsuit is not political?
Oh, absolutely.
Can you say who you're voting for governor?
Oh, I would keep that to myself, but I keep saying I'm a card-holding Democrat. I'm a Democrat 100%.
Will you vote for JB Pritzker then?
I'm going to vote for whoever I think is best in the election. But remember, this isn't about me. It's about my plaintiffs and their civil rights.
So working on a campaign, several of these people, as you cited and laid out in the lawsuit, they've worked on campaigns before.
Right.
These are tedious jobs. They're difficult jobs. Can you say which one of your plaintiffs worked for the Pritzker campaign the longest?
Off the top of my head, I cannot say which one has been there longer. They've all been there varying amounts of time.
But none of them have been there longer than 6 months.
Again, I can't say exactly. I don't want to quote a number that's wrong. But for a campaign cycle, usually what happens is, I'm sure you know, but there are people that work for the primary, and then usually for the general election, a new group comes in. So 3 to 6 months is not unusual for a campaign cycle.
But were any of your plaintiffs working for the campaign before the primary?
I don't believe so.
I believe the answer to that is no. I believe the person who started there the longest started in June, so less than 6 months. Some of those campaign staffers that were already there, that they joined their ranks, had been there for a year and a half. Is that correct to say that?
Right.
Your lawsuit says that they were not offered a position for advancement, or they weren't offered a chance to advance. How many campaigns have you seen where someone comes in, has been there for 2, 3, 4 months, and has a position to advance? Weren't many of those positions already filled?
No. So the main issue is that many of the positions for advancement were not put on public notice. There wasn't a public forum you can say, this job opening is open, you can apply for this. This is open, you can apply for this. So that's the main gripe. And secondly, I mean, people can come from the outside and get that position and apply for a position, get a position, and be there for no time. So if you're there for one day, you still have the opportunity. You should still have the opportunity to be able to apply.
So you're saying the absence of a public notification was grounds for discrimination, but weren't some of those positions filled by other people of color? How then can you prove that it was discriminatory?
Absolutely. If those positions that weren't put on public forums, or even if they were even put on public forums or put on notice to other people that are not minorities, then that's a problem.
But if the position was filled by a person of color?
That's not necessarily the issue we're looking at. We're looking at...
But there were instances where the people that, the positions that you're pointing to were filled by people of color, no?
There may be. There may be. But what we're looking at is that all those openings were not put on public forum in order to give every person an opportunity to be able to progress.
I guess the point I'm driving at here is that campaigns are tough environments to work in. They're very demanding. Mm-hmm. And like you said, there are no weekends. People work 7 days a week. They run them ragged. In your experience, what is the difference between a demanding employer and a discriminatory one?
The difference between a demanding and a discriminatory?
A demanding job, a demanding employer where you're asked to do difficult things, you're asked to lift a Herculean workload, and where's the line? Where does that cross over into something that is discriminatory?
I don't believe those two are similar. You can be demanding and not show discrimination.
Some of the work conditions and the things they were asked to do were cited in your lawsuit. That's why I bring that up.
Well, the work conditions are cited because the work conditions they had were different from people who weren't similarly situated. When they asked for certain resources, they couldn't get it. People who were similarly situated got it.
What's an example of that?
If you asked for a certain amount of money for an event or something to that effect, you were told you're going to get it, and then that money was taken away. A similar type of event in a different area with different demographic, they were told they would get this similar amount of money or a similarly situated amount of money, and they get it.
So is it fair to say then that all of the different instances of discrimination that you're alleging are not included in your website, or in your lawsuit rather? Because I don't know if I saw that example.
Well, yeah, no, any lawsuit, when you file the complaint, there are always going to be other facts or other issues that come out later during the discovery process.
So let's discover some more of those facts then. In the example of Peoria, your lawsuit says that there was a Democratic household who was supposed to be hosting Casmine Calhoun, Correct. One of your plaintiffs. But your lawsuit alleges that when they learned she was a black person, they denied her housing. What was the name of that household?
That I'm not going to release at this time.
So you can't say the name of the household that turned her away?
I'm not going to say at this time, correct.
But at some point you will?
That's the hope.
But the campaign, so we don't know the name of the family. Was the family, can you say if they were hired or on staff of the Pritzker campaign?
I'm not going to say that either yet.
Would it be fair to say that a person who was not working for the campaign, say it was a volunteer household, how would you prove that the Pritzker campaign was liable for their actions?
Well, easy. If someone is volunteering to do a favor for the campaign, there's some kind of connection to the campaign. And if that person or the volunteer is an agent of the campaign, in essence, and they do something that is illegal, and the campaign does nothing to address that, then they're liable for that.
So a volunteer of the campaign makes the campaign liable for the volunteer's actions?
A volunteer can be an agent, absolutely.
Okay. Your lawsuit says when the family found out that Casmine Calhoun was black, they denied her housing. As a result, she was forced to sleep in her car and at the campaign office. The Pritzker campaign has produced multiple receipts from different hotels, some of them about $120 a night, where they accommodated her request and moved her quickly. Does that poke a hole in this theory that she had to sleep in her car?
No, she had to sleep in her car.
Paid for a hotel.
She had to sleep in her car, and she had to sleep in a campaign office. That is 100% true. We've never said that later on perhaps the campaign tried to do something after she had to sleep in her car, after she had to sleep in the campaign office, which I think is ridiculous.
Your lawsuit says the campaign, I'm quoting the lawsuit now, it says the campaign still refused to move her to a safer location.
Well, what that means is,
true?
No, that doesn't mean that a car in a campaign office isn't a safe place to sleep, but that doesn't mean that when she got to a location that location wasn't safe.
But you don't deny or dispute the existence of those hotel receipts and the availability of a hotel?
I haven't seen those.
Okay. Regarding safe work conditions, we mentioned this earlier. Back to Chicago. This is not in Peoria now. This is in Chicago. Your lawsuit says an alderman offered to let the plaintiffs use space for free in a safer location,
right,
but that request was denied. I'm assuming by the campaign?
Yes.
Who was the alderman?
I don't want to say that at this time.
So you're not saying the name of the alderman who's alleged in the lawsuit. You're not giving us the name of the household that was alleged. Why not? Wouldn't that solidify your case?
I don't need to solidify my case. The way we solidify a case is in the courtroom, not not in this kind of forum.
I understand. So again, how would JB Pritzker's campaign be liable for the action of the alderman, or how do you're saying you're going to be able to produce evidence or documents in a courtroom that?
Absolutely. And so, in essence, what we're saying is that the minority workers, they asked for a safer place to be able to have their office. The reason the alderman is even brought up is to show that they had an alternative. They came up with an alternative, and yet their alternative was still denied by the campaign.
Will that alderman testify on the behalf of this case, do you expect? Have you been in touch with the alderman?
We'll see.
Have you been in touch with the alderman?
We'll see. We'll see. Just like with any case, any civil lawsuit, we subpoena people, we bring them in for depositions, and then if we need them later for trial, we subpoena them for that then, at that point.
Of course, that would happen long after this election is over.
Absolutely.
You have, not political maybe, but ambitions of your own, right? You've campaigned to be a judge?
I ran for judge, yes.
And that effort fell short.
Correct.
But the Illinois Attorney Registration and Disciplinary Commission, the ARDC, I'm sure you're familiar, charged you with making false statements to a court.
Right.
Have you reconciled that with the ARDC, or is that still pending?
Oh, I went to hearing, and we're still pending.
It's still pending?
Yeah, yeah.
The Bar Association went through and rates, they rate lawyers who seek to become judges. They said that you're not qualified for the bench. Do you agree with their assessment?
No, no. But again, this lawsuit isn't about me. It's not about any other attorney who's doing the case. It's about these 10 people and having their civil rights violated.
But you understand why other Democrats who want to see JB Pritzker win see this as a wound that you and others have inflicted to his campaign. And so you understand why people have raised questions about your motives here.
No, I don't. Because it shouldn't matter when you're dealing with someone's their life, their liberty, their civil rights. What's right is right. So no matter who is on the other side of the lawsuit, people shouldn't question that. You shouldn't consider a wound. You should look at it as an opportunity to investigate and right what has been wrong.
Do you still have ambition to wear the robe to become a judge?
We'll see what the future holds.
Is that something that you're pursuing? Something that you'd like to do someday still, or have you crossed that off your list?
Well, again, it's hard to say what the future is going to hold.
And do you expect that there's been some rumor, some other people, Keena Collins, who worked for the Pritzker campaign back in the primary, came out and said she can corroborate some of the nature of the work conditions, some things like that. Do you expect that she or perhaps others may join your lawsuit? Will your ranks grow larger?
Perhaps. We'll cross that bridge when we get to it. But I think that, of course, is one person. She left a long time ago from the campaign, and she's already come out and said that the allegations here ring true.
If your case was about civil rights, and if it was about the events that happened in the last 6 months, why then include the recorded conversations of the wiretaps from 2008 that Governor Rauner has used in his election messaging? Why include that as such a prominent portion of your lawsuit?
I think it shows that there is perhaps a pattern here in regards to the violation or discriminatory action against people of color.
Do you think JB Pritzker is personally responsible for the actions that your plaintiffs allege happened to them?
Well, we've sued the campaign.
Do you think he's personally responsible?
Well, again,
you just said there was a pattern. That was JB's person in 2008, not the campaign. You said there was a pattern.
I said perhaps there was a pattern, and we've sued the campaign, so that's who we're going to go forward with the lawsuit against.
What are the chances a judge throws this out as a frivolous lawsuit?
Percentage-wise, difficult for me to say.
Are you at all worried about that, this
No.
being called a frivolous lawsuit?
No, not at all.
Do you understand why the campaign, though, as they produce evidence of the hotel receipts, and we still don't know who this alderman was. We don't know who the mysterious household in Peoria was. There's still a lot of open questions here. Will you answer any of those before Election Day?
Maybe, maybe not. Again, I'm a lawyer.
How do you make that calculation?
Well, I'm a lawyer. So what I do is I handle things in a courtroom like lawyers do. The campaign.
You're here on a TV show to talk about your case.
Absolutely, absolutely.
So you're bringing it. This is a very public issue.
Absolutely, I agree with that. But still, at the end of the day, I'm still a lawyer, and my job is to bring facts and deal with the case in the courtroom, not in the court of public opinion. So they're going to continue to try to poke holes because they're politicians. I'm not.
Sure. And you've also called for a number of different actions outside of the damages to be paid, like positions being posted on a public website, and it specifically mentions not just in the campaign. So your fight won't end on November 7th, after Election Day. You want the administration, should JB Pritzker be elected, to live up to a certain standard when it comes to diversity, when it comes to anti-discrimination, preventing discrimination. Can you explain quickly what some of those issues are that are important to you, that you want to see a potential Pritzker administration uphold and live by?
Sure. The main issue we've asked for is a chief diversity officer. And a chief diversity officer would be part of the administration. What that person would do would make sure to create a series of checks and balances to make sure that if minority people that are involved in the administration have any types of issues, that at the very least there's an investigation and those issues are actually taken care of as opposed to being ignored.
How has Governor Rauner done in that area?
In regards to what Governor Rauner's done in that area, I'm not sure.
But you're familiar with Springfield. You've lobbied in this building. You're familiar with the politics here and in Chicago. How has Governor Rauner done so far?
Again, I really want to talk about the case. I don't want to get into politics. Remember, I'm not a politician. I'm a lawyer.
But you're a lawyer who deals in diversity and civil rights. Have you seen any issues that would be troubling to you in the Rauner administration?
In regards to Governor Rauner and his administration, I haven't focused on that. What I focused on in particular is this particular case.
All right. It was good to have you with us. Thank you for explaining your case, and we look forward to seeing how it's resolved.
All right. Thank you much.
We're back in a moment with our Reporters Roundtable. Stay with us.
All righty. Thank you kindly.